Yeah, no, it's on my list.
Okay, good.
She's been great.
Yeah, I know.
She's been amazing.
She's amazing. She deserves to get all the accolades.
And all of it from the end.
And anyway, she's become the president of your fan club.
She's literally with an exclamation point on my list.
She's the president of your fan club. She said, I guess you must have sat in on your boot
She
camp.
loved the boot camp.
She
It
said
was-
it was the most fantastic thing.
Oh, I'm glad. It was fun. It was a lot of fun. Welcome back, folks. If you could find your seats, get that last cup of coffee, maybe some water, and we're going to get started. Once again, if everyone could just take their seats, we'll get started. Goodness gracious me. The house lights are down. Welcome back to the Fitch Forum. It's good to see that everybody, looks like everybody stuck around for the afternoon session, which we're very, very pleased for. We've got some important things to talk about. Our next panel is going to focus sort of our conversation from the national level and then from the sort of looking around the nation level, right back in on New York City. This is a celebration of New York City's landmarks law, and we're going to take sort of a hard look at it and ask some questions, right? What are some things we might want to think about improving our landmarks law? What are some of the problems that we're confronted with as preservation advocates? So before we get set to sort of tear down the landmarks law and take that vicious look, we're going to take a couple minutes. We're going to take a couple minutes to talk about the landmarks law. One of the things that I think is really important and that we heard from, we're not actually Mark and Marjorie going to do anything of the sort. You know, one of the things that we've heard this morning that we hear all the time, right, is that people don't really know too much about their landmarks law. They don't know in New York. They don't know in other jurisdictions and municipalities that have ordinances that are modeled on New York. So I'm going to set myself a timer because I'm going to be really strict with me about the time, and we're going to take a look at the city's landmarks law. Before we can ascribe sort of the normative criteria to the landmarks law, it's probably important to look at some of the sort of jurisprudential and philosophical underpinnings that brought us to having such a robust and celebrated landmarks law. And I removed some slides. We're really not going to duplicate, to the extent possible, the things that Gerald spoke about this morning during the keynote address for a couple reasons. The first is that you've already heard it. The second is that there's no way I could do it nearly as well, and I don't want to embarrass myself. So where you see me start to be duplicative, I will retreat, and I hope you understand. Right, the jurisprudential and philosophical underpinnings of the landmarks law are important. The notion that the government can regulate private property for purposes of health and safety, for purposes of the general welfare, you know, it's something that we in this room all sort of hold as sacred and obvious, but it's actually, it's pretty not obvious. Not to echo the calls of the property rights movement, with whom I disagree on many things, it is a spectacular thing that we have a landmarks law that does allow us to regulate private property for this purpose. It is not an unreasonable thing. It is not something that we should question as preservationists, but it's something that we should really, really appreciate. And it didn't just sort of happen. It evolved. And it evolved because the national legal scape, starting sort of at the early 20th century, was shifting to adopt what is sort of a modern understanding of the regulation of private property. In 1916, spurred on by the impact of skyscrapers on light and air, and spurred on by the real estate industry, and also because of the impact and the encroachment of factories on fashionable residential neighborhoods in New York City, New York City passed what is arguably the nation's first zoning ordinance. That's in 1916. Because Linda mentioned it, there's a footnote there, right? LA beat us to the punch here too. In 1909, there was a zoning ordinance in Los Angeles. It wasn't as comprehensive as the city's zoning ordinance, but they at least deserve some recognition for getting us there, getting there first, as they did with their landmarks law. So again, in 1916, we have the city's zoning ordinance, and then in 1921, Secretary of Commerce Herbert Hoover convened a committee to consider the question of zoning. And that group eventually promulgated what's known as the Standard Zoning Enabling Act. So, out of nothing, sort of after the turn of the century, we start to see, stemming in part from the City Beautiful movement and in part because of just sort of the modernization and the urbanization of our, well, can't say the urbanization of our cities. Because of urbanization, we see zoning has sort of come to be. And then in 1926, in a case called Village of Euclid v. Ambler Realty, the Supreme Court sort of sustained the constitutionality of zoning and made clear, right, that the government can regulate private property, notwithstanding the fact that the regulation might diminish the value of that property. And they could do that. You can do that without violating, the court said, the due process or equal protection clauses of the United States Constitution. And this is really important, right? This is the court saying, and as Gerald pointed out earlier, the court was not actually, the court wasn't part of some grand movement. The court was doing this in part to protect private ownership, right? This was to protect the value of your property. The government could step in and regulate the way your neighbors use their own property. And this is not new. This stems from nuisance abatement and sort of a long line of cases that we won't get into, but it's significant. And it's significant for our purposes because it came on the heels of another Supreme Court decision that has implications for our own landmarks law, and particularly Penn Central, right? And that is the Pennsylvania Coal v. Mahone. This is the famous announcement of the court that, the government can't just sort of, the business of government can't happen if the government can't regulate property without having to pay for everything it does. So recognizing the need to regulate property, the court went on to say that while property can be regulated, if a regulation goes too far, it's going to be recognized as a taking, and that's impermissible. And that's the big question that was subsequently answered, at least answered in part by Penn Central, and that's the void that a lot of our preservation jurisprudence is struggling with now. When does a regulation go too far? So we can synthesize these cases, and what we see is that sort of temporally, by this point, we know that the government is not considered to have run afoul of the Constitution when it regulates private property in the interests of health and safety. And what's great, right, is that health and safety is pretty broad and inclusive, and it's a short jump from health and safety to public welfare. And public welfare, as we all know, is a pretty broad and encompassing statement as well. And we see in a subsequent Supreme Court decision, that of Berman v. Parker, which was also alluded to this morning, the concept of public welfare is broad and inclusive. This was in the context of a condemnation, but the issue here was absolutely on point for preservation purposes. We want to have a public welfare that encompasses the spiritual as well as the physical, and the aesthetic as well as the monetary. Communities should be beautiful as well as healthy, spacious as well as clean, well-balanced as well as carefully patrolled. The highest court in the land has now pretty much said that the government is in the business of regulating for the public welfare, and public welfare includes aesthetics. And that is sort of the background to our landmarks law. Berman v. Parker was 1954. The landmarks law didn't just sort of happen after 1954, of course. There had been people advocating for such a law in New York for many years. But it's unsurprising that with this sort of nationally evolving jurisprudence and the city beautiful movement and the sort of transformation of the city's arts societies into what are essentially urban planning think tanks early on, that we'd find a landmarks law to come out of sort of this philosophy. And that's precisely what happened. Our landmarks law was passed shortly after Berman v. Parker in 1965. It mirrored something called the BARD Act, And it's interesting to note that the BARD Act was sort of first drafted in 1913 when some of these ideas about zoning were very sort of just being floated around. So the idea of aesthetic protection and the protection of historic resources has really been sort of, you know, it's been a passenger in the vehicle the whole time. It only sort of surfaced, though, really with the passage of New York City's law. But despite the fact that we have this underpinning, right, New York City is still losing buildings. And it's important to remember that while we were talking about zoning and we were talking about early talks about historic preservation and we're talking about protecting aesthetics, right, this is a city that was losing buildings. And that's not surprising, right? In the absence of a robust preservation law, New York City will demolish its historic resources. This is a city that's characterized and defined by two things, right? Forward momentum and finite space. This is a recipe for demolition, and this is why New York City so badly needed a landmarks law. Some of the buildings that, you know, very well might have been protected, probably would have been protected under a landmarks law, include the Astor Hotel, which was demolished, what's that, 1926? The Marble House, which was demolished in 1951. The Mark Twain House, which was also demolished right around Berman v. Parker in 1954. And of course, the all too familiar Penn Station, which was demolished just as right before the passage of the Landmarks Law in 1963. And, whoops, the future Penn Station. Wow. So, you know, that's unfortunate. So one of the issues about being sort of a coordinator for this conference and also speaking in it is that I sent all of our participants really nasty emails that said you had to have your slideshows done a week ago, you had to get them, and then I promptly ignored them. And so and this one, by the way, is going to come back because I used it twice. I pasted the wrong slide into the slideshow, and man, I wish I hadn't done that. So we're just going to keep going. This is the Brokaw Mansion, though, which was demolished in 1965. Gosh, that is going to haunt me for the rest of my time in New York City. I am really unhappy about that. I need to compose. Okay, so the Brokaw Mansion is demolished just as the New York City Landmarks Law is passing. And so let's talk about the Landmarks Law that came out of sort of this incredible need and this pressure to save our historic resources and the jurisprudential underpinnings that we've discussed, right? When we talk about the City Landmarks Law, we're not really just talking about one law. We're talking about the city charter, which governs the way we protect historic resources and the way our city commission works. We're talking about the city administrative code, which is when we talk about the Landmarks Law, we're often talking just about the administrative code, and the rules of the City of New York, which are those rules promulgated by the agency. Today, just because of timeliness, we're not going to talk about the rules of the City of New York. We're going to very briefly talk about the city charter, and then we are going to talk about sort of the purpose and declaration of policy that's in the New York City Administrative Code, because if we understand what we wanted out of our landmarks law, that we might be able to sort of understand if we're getting that out of our landmarks law. So I'm going to breeze through this, and man, I hope you've all already forgotten about the slide. So the city charter does speak to what our commission can do, and the first thing it does is says that there shall be a landmarks preservation commission. It requires that commission consists of 11 members. Many of you are familiar with this, some of you are not, so I'll go through it quickly. Right, we have to have a minimum of 3 architects, 1 historian qualified in the field, a city planner or landscape architect, and a realtor. All must be on the commission. The commission must have representation from each of the 5 boroughs. Members of the commission are appointed by the mayor. The mayor is permitted but not required to consult with the Fine Arts Federation or similar organizations when appointing members. The mayor is required to designate a chair. The chair is the only commissioner who is paid. All of our other commissioners are volunteers. Members serve for 3-year terms, and they do so very generously, right? Because they're working for free. Right, so there's also the staff. The commission must appoint an executive director. They must submit an annual report of its activities, and they are permitted to employ technical experts and employees as may be required to perform its duties. And of course, agencies need to have staff, and they need to have their staff do a lot of work. Some of the powers and duties that are covered in the city charter include, well, first of all, it includes a reference to the administrative code and says that the commission shall have those powers and duties as are prescribed by law. There are a number of notice requirements that are included in our city charter, and there's also sort of a democratic check on our Landmarks Commission, and I think that's important to highlight, right? That this commission does have such a check, right? So while the charter makes clear that landmarks, landmark sites, interior landmarks, historic districts are in full force and effect upon designation, some things can happen. The city council can modify or disapprove by a majority vote any designation of the LPC within 120 days of the filing of that designation with the council. That's sort of one sort of safeguard that would sort of overlook the commission, right? The mayor can then disapprove a city council's decision within 5 days of the filing of its vote on the designation. And then if the city council really doesn't like what the mayor did, the city council can override the mayor's veto by a 2/3 majority vote, so long as they do so within 10 days of the filing of that decision. Those are sort of the powers and duties of the commission that are in the charter. And one other thing that's in the charter that may come up during this panel discussion, so I'll mention very briefly, is that after the decision in St. Bart's in 1989, the voters of the city of New York by charter elected to create a hardship appeals panel. This is a curious thing, right, because it's never actually been convened, but the Hardships Appeal Panel is independent of the commission. It consists of 5 members who are appointed by the mayor with the advice and consent of the council, and they review appeals from determinations of the LPC denying applications for hardship for nonprofits. We're going to talk a little bit more about hardships in a minute, and this is really just a footnote to that conversation. So now let's get to sort of the meat of the conversation, right? The New York City Administrative Code, this is what we talk about when we talk about the Landmarks Law. It does a number of things. It states the purposes and declaration of policy underlying the law. It also speaks to the powers and duties of the commission. It details, the degree to which we can regulate property subject to the jurisdiction of the commission, and this is that extraordinary power, right? This is the Landmarks Law has the authority to regulate privately owned property. And it also established certain civil and criminal penalties for noncompliance. I'm not going to talk about those at all because we have an expert to talk about that later today. All right, so let's look at the Declaration of Public Policy. The council finds that many improvements having a special character or a special historic or aesthetic interest or value, and many improvements representing the finest architectural products of distinct periods in the history of the city have been uprooted. So in some sense, the Landmarks Law is very much in response to the phenomena we were discussing, where the city's most sacred sites, most important buildings were, not the most sacred sites, the most important buildings were being demolished. And we can look to the architectural features of the Brokaw Mansion, and we can say this is exactly what they were talking about. This is an architectural treasure that would have benefited the city but was lost, right? This is happening notwithstanding the fact that these buildings can be protected and they can be used, they can continue in their use. Now there's a really unfortunate slide. So we're just going to keep going because if you cut and paste once, you cut and paste twice, and I really wish that hadn't happened. But we'll continue, right? So in the public policy, this is sort of a lament, right? We've been demolishing these incredible buildings without adequate consideration of the irreplaceable loss to the people of the city of the aesthetic, cultural, and historic values represented by such improvements and landscape features. And this is something that Gerald brought up in his keynote, right? This is the sense of place that comes from these buildings. This next slide is a little bit better, right? When we talk about when we talk about treasures that we've lost, we do look to Pennsylvania Station, and we do look to the sense of place that was created there. Anyone take the train in today and come through the current Penn Station? Right? I'm pretty sure that this is better than what you walk through today. And so when we talk about an irreplaceable loss and we talk about a sense of place, we're talking about sort of that feeling, that sense of pride that comes from our architectural treasures. And that's very much in the Landmarks Law. The Landmarks Law was very thoughtful in that regard. There are no more pictures of wrong buildings in this presentation. We'll continue. So again, continuing with the Declaration of Public Policy, this is cool, right? Distinct areas are similarly uprooted, right? So we're not just going to protect buildings, but we are going to protect historic districts. And this is also in recognition of the sense of place that comes from the preservation of neighborhoods and neighborhood characters. Thanks. So we're going to look quickly at 2 of them. Brooklyn Heights and Greenwich Village are 2 of our most famous historic districts. And again, in the Declaration of Public Policy, it's the sense of the council that the standing of this city as a worldwide tourist center and world capital of business, culture, and government cannot be maintained. Right? This is very, very passionate language for a run-of-the-mill ordinance. And it's important to remember that it's in there. When we as preservation advocates feel that we might be pushing too hard, let's remember that the purpose is in the law, the declaration of policy is in the law, and it's pretty bold and it's pretty ambitious, right? And that's sort of the I Love New York part of the law. I am way over time already, so I'm gonna, probably because I do, right. Do you want me to skip the hardship and we'll save it for the conversation? Okay, so we're gonna put aside the hardship conversation that I promised you, and I'm actually gonna just bring this up. When we talk about what the city can designate, we talk about landmarks. Of course, we talk about Grand Central. Gerald covered that in great detail. This could have been Grand Central, guys. It could have been really bad, but we designate landmarks and we protect them. We talk about interior landmarks when we talk about the landmarks law. We talk about scenic landmarks and historic districts. I'm going to run through these numbers and then I'm actually going to stop. So this is a map that MAS provides. This looks at sort of what we've designated. And just in terms of what we've got, what we've accomplished, right? The city has about 27,000 buildings under the jurisdiction of the LPC. 1,280 individual landmarks, 110 interior landmarks, 10 scenic districts, 102 historic districts, and 16 extensions of the historic districts. That's about 3% of the city. So Tony, I'm going to stop there so we can get to the conversation. And right, no. So again, wrong slide. Sorry. Quickly to introduce Tony, who'll be moderating our next panel, right? Tony is known to just about everyone in the room because he either invited you or strong-armed you to be here. Tony is founder of the New York Preservation Archive Project. He's a preservation activist, a writer, a teacher here on the faculty, and he's going to moderate a conversation now. He'll introduce everyone on the panel.
There will be a test on David's presentation, so I hope you all took notes on that. Well, great. Today we've assembled a distinguished panel of lawyers with different backgrounds and different perspectives on preservation law in New York City. It spans the generations, and it spans a wide range of viewpoints. Their longer resumes, as we've said, float virtually on our website, so I'm going to be very brief in the introductions, but some indeed are required. So raise your hand when I'm introducing you. Al Butzel, and I'm doing this in alphabetical order, is the principal of Al Butzel Law Offices. He's practiced law and led advocacy campaigns in New York City since 1965, from the Storm King Mountain Power Plant case to his legendary successful litigation against Westway, to more current legal efforts such as those on behalf of Albert Ledner's National Maritime Union headquarters, also known as the O'Toole Building to some of us, in Greenwich Village Historic District. He's represented St. Vincent de Paul in an effort to secure landmark designation of that historic French church, blessed by the presence of Edith Piaf. And he's working he worked with the groups that were trying to downsize the Atlantic Yards project. So Al has become the go-to lawyer for those unsatisfied with planning in the preservation status quo. Otis Pratt Pearsall is truly a legendary person in the history of preservation in New York City. As a young lawyer, not to suggest he isn't a young lawyer still, new to Brooklyn Heights in the late 1950s, he was part of and came to lead the effort to secure landmark protection for Brooklyn Heights. In that process, he actually drafted a landmarks ordinance prior to the city ordinance and then worked on getting the city ordinance secured. 102 historic districts ago, Brooklyn Heights became the first district designated after the passage of the law, and Otis has been active ever since. Marjorie Perlmutter is a partner in the law firm of Bryan Cave, specializing in zoning and land use building code and related environmental issues. She represents private developers, public institutions, and nonprofit groups before the New York City Planning Commission, the Board of Standards and Appeals, the Department of Buildings, community boards, borough presidents, all of our friends. She's there. Marjorie is a member of the New York City's Landmarks Preservation Commission, and until 2006, she was a member of Manhattan Community Board 8. And perhaps most importantly, this semester she's teaching here in the preservation program at Columbia. David Schnackenberg, who we've heard from, we won't say anything about slides, is an attorney and the former Ralph C. Menapace Fellow in Urban Land Use Planning at the Municipal Art Society. While in that position, he was involved with a variety of preservation legal issues, including the St. Vincent's Hospital hardship hearing. And he's also a guest lecturer in the Columbia Graduate School of Architecture, Planning, and Preservation, and the coordinator of today's event. Mark Silberman is the general counsel to the New York City Landmarks Preservation Commission. Prior to working for the commission, he was a litigation associate at Paul Weiss Rifkin, Wharton and Garrison, where he specialized in environmental and general commercial litigation. In the 1980s, he was a lobbyist, organizer, writer, and editor in Washington, D.C. for various environmental and public interest groups. So the overriding question that our high-octane panel is going to address is New York City's landmarks law at 45 perpetually young or showing its age? Based on years of observation, I think one can say that most, if not all, of the rest of the country is envious of New York's landmarks law. New York is indeed blessed to have such a robust law. However, New Yorkers are not known for just sitting back and counting our blessings. They're always striving for more and better. And frankly, I think a few were in shock over lunch to realize that everybody thought our law was so terrific. The conversations recently over charter reform, a variety of disappointments over the years, including losing a number of buildings, the failure of some legal challenges to achieve change, have caused some to wonder if it's time to devote some serious thinking to the notion of tweaking or amending our landmarks law. The Preservation Vision Project, which involved close to 500 preservationists thinking about the future of preservation, came up with a list of 10 things that we needed to focus on to secure preservation in New York in the future. The fifth on that list in order of priority was strengthen the landmarks law. So our law is almost 50 years old. The world's a different place. Arguably, the law has only been substantially amended once, in 1973. So the law has remained basically unchanged for 38 years. So is it perpetually young? Were its drafters successful in creating a document that could evolve over time and successfully meet every changing need? Or is it showing its age? If it is showing its age, in what ways? And if it is a prescription a little Botox? Is a description a facelift? Or is a prescription just to learn to live with it and love the wrinkles that it has? This panel will explore these and other questions. I'm going to start by guiding our panel through a much briefer series of questions than I planned, because I want to open this up to the audience, to explore three areas of interest. First, we're going to look at what's transpired since the passage of the law, talk a little about how we got here. Then we're going to look at some of the current challenges and opportunities that the law faces. And then we're going to be looking really at the future. We're going to do this probably for about 15 minutes. We're going to open it up for Q&A. I'm going to direct a question at a particular panelist just to start it, and then invite the others to comment. Everybody doesn't have to comment on every question unless they want. I'm going to try and move us along, and I'm going to do this in a kind of a Charlie Rose style. So I'm moving over here, create more of an intimacy with the panel. You got to love it, guys. Okay. Al, you promised to behave. Okay. Trying to get an overview on the last 45 years of the application of the law, the record is clear that in the early years, the Commission proceeded very gingerly. Preserving the landmarks law was its greatest concern. Frank Gilbert, the executive secretary of the Commission, had a sign on his desk at that time that read, "This law raises grave constitutional questions." The first and second chairs of the Landmarks Commission maintained that indeed preserving the law was their top priority. Some suggest that after Penn Central, the Commission was more aggressive in the application of the law, leading to a period of creativity and activism, but also conflict and controversy. Since 1994, some have observed that the Commission has become more restrained in its application of the law. Is that a fair characterization of the last 45 years? And if not, in broad terms, how would you define or describe how the law's application has evolved in that period? And notice I'm going to ask you to start because you've been here through the whole thing.
I may be the only one in the room who's been here through the whole thing. It's been a great honor to be here through the whole thing, and I have to say that I think if I have to vote between perpetually young and whatever showing its age, I think it's perpetually young. This is the most remarkable success story that I can imagine. When we were envisioning a landmarks law starting in 1958, it took us 7 years, A, to get a landmarks law, and B, to get Brooklyn Heights designated the first historic district. Nobody had in mind 110 historic districts. We thought of maybe 3 or 4. In our discussions with Platt and Goldstone, it it was always Brooklyn Heights, Greenwich Village, Gramercy, and maybe 2 or 3 others. But no one had the foresight to envision the flexibility of this law and its utility not only to preserve buildings and districts, but entire neighborhoods. The whole neighborhood preservation idea came into vogue with Beverly Spat. She was the one who first saw the potential here to use it as a planning tool, which gets us a little bit over into one of the issues this morning. With 110 going on 250 historic districts, one has to step back a little bit and wonder just what exactly it is that we are trying to achieve and what we are doing. Are we cheapening the brand, or is this the correct thing to be doing? Until there is a mechanism here in the city to preserve neighborhoods other than the landmarks law. The landmarks law is the name of the game, and we're going to have to go charging ahead with the preservation of valuable neighborhoods through the historic districting mechanism. Now, your question is a little broad. I think that some of the subtleties of were we going fast at one point or were we going slow at another point, I find very confusing because everything is sort of drifted into the mists of time in terms of the actual energy levels of the different commissions.
That's
over
very
time.
fair. That's very fair.
But anyway, I think that I certainly have my own pet thoughts as to what can be done to improve the landmarks law.
And I'm going to ask you to hold those till we ask
I'm
that
not
question.
going to give them. I'm not going to share them with anybody. I'm just telling you I have them. But I want to be optimistic when I think about the New York Landmarks Law when you consider what has been achieved. I mean, we can carp and we can pick, but the fact of the matter is it has been a remarkable success. That's not to say it can't be improved both in the law and in its administration. This audience is filled with people who could go and particularize item by item what needs to be done to improve it. But the fact of the matter is, it's not a bad instrument as it is right now.
We will move to the carping and picking a little later. Other thoughts on whether that's a fair way of looking at the scope of the
Sure.
commission's work over time or not?
Well, unlike Otis, you've been in it for 50 years? I've been in it for 3 years, so I have to look at it in a significantly different way. I didn't realize you were that old, actually.
We started in 1958.
Oh, well, so it's 60 years. I'm sorry. Please forgive me. I think I agree, though, just looking at it as an outsider to begin with and now more as an insider, that it's a remarkable law and it's achieved remarkable things and undoubtedly achieved things well beyond what anyone would have anticipated at the time. The law, though, and Otis really adverted to this, depends a lot on the commission that's enforcing it and interpreting it. And as at the beginning of the process, the greatest concern was to maintain and uphold the landmarks law, which happened with the Grand Central decision and then was carried forward with the St. Bart's decision, both of which are extraordinary cases, extraordinary judicial law. There are issues now that are rising, the most recently in the St. Vincent case in which I was involved, where the commission itself, in my judgment anyway, diverged from the Grand Central and the St. Bart's decisions, concluded that it was appropriate not to address a building as a building, but rather to accumulate buildings on a campus, the so-called campus theory, the consequence of which could be that historic structures on a campus like Columbia, for example, might be subject to demolition, this within a hardship context where even though they are capable of being reused, even though they are capable of adaptive reuse. And I think that we're never going to get a court decision on this because St. Vincent's conveniently went bankrupt But it is one of the issues that people are going to have to grapple with, and whether there's a legislative solution or ultimately a legal decision, that issue will have to be addressed.
Lots of things have gone on the table, so I started with kind of looking at the history. Other things have been brought up, so go with it where you want and respond.
No, I think that since I'm 52, I think of this as perpetually young, the law, but I think that it's really useful for everyone in the audience to hear how important New York is to everybody and how just sort of critical the law that we take for granted here every day. And the other thing that I think is important to remember is all of the people coming from the other jurisdictions are talking about the practical realities of actually administering a law is very complicated. And one of the dangers is to think that preservation is a vehicle for handling lots of urban problems. And I believe, and for me, I felt at home with the panel in the beginning of talking about the need to try to separate out our impulses to make preservation be the sort of paradigm through which all good urban new ideas should be sort of funneled and refracted out. And I think that's a mistake. And I also think that as the commission and commissions become more mature, and as they have more and more power over the economic welfare of the cities in which they are operating. I mean, to hear Otis say, no one ever imagined this, I think is both great and it's also a cautionary note. What was it when all this discretion was granted to the commission in 1965? I mean, if you think about, and I'll ramble a little bit, if you think about the sort of levels of discretion that happen in the law, it's pretty remarkable. You have great discretion being given to the commission. But at the same time, the people who drafted it maybe had a narrower view of what they were engaging in. What was the kind of the area of discretion? Then you have the courts who are saying, I don't want to weigh into this. I'm going to leave it up to you guys. And then at the same time, you have the law itself evolving as what counts as historic preservation gets broader and broader. And I think so that it gets more and more attenuated as time goes by. And I think that what commissions have to do is, and as our power over larger areas of the city grows, I think the danger is to think that preservation should be this incredibly sort of, and I don't want to use the word rigid, but sort of formulaic thing, when in fact it requires great degrees of discretion, which makes a lot of people uncomfortable. And my job as a landmark, as the counsel of the commission, is to try to make sure that when the commissioners are debating something, that the discussion is taking place within the legal framework of the law. But I do believe that the commission has to be able to have discretion. It has to be able to deal with new situations in new ways. And we may have a conversation, Al and I are litigants in this case on St. Vincent's, and if, we can talk about that case in more detail. But this was a case, just to sort of remind everybody, this is a case, the first time ever, where the commission had to deal with this question of, okay, we have a building that, and for purposes of our discussion now, was decided could no longer function for the purposes for which it was created, the hospital. But you had to use that building while you had to find a place for a new hospital. That's a situation the commission's never had to deal with before. What happens when you found that this is a problem, you recognize the need for a new hospital, but you can't just have them move and do something else. So the commission, I think all commissions, not just New York, all of them are dealing with real matters of first impression, real matters of how we regulate, and I think discretion is going to be a very important thing to keep in mind as we discuss how do we want to change the law.
I just want to pick up on some of the things that Mark was saying. Like all laws, they develop as people use them. And when a law just sits there and no one actually touches it, you don't see how it affects your world or anyone else's world. And the more, for instance, in economic development times and boom times, you see how the law is being implemented and how people are trying to use it. And I haven't been involved in historic preservation for decades. For me, it's more like a few, maybe 10 years. And, but what I have seen is that, as for example, as a member of a community board, I have seen how community activists use historic preservation as a way to limit development. And that's not what historic preservation is for. That's called zoning. And what I'm seeing more and more, which I think is a very unfortunate trend in sort of the historic preservation movement, and therefore an imposition on the law, is that people will see that designating a historic district or designating a building can actually be a speedier way to eliminating a development possibility than convincing the City Planning Commission that it would be a wise planning move. So, so there's that I think really needs to be looked at. I think interesting, I think one of those panelists from an earlier conversation was talking about, I think it's Chicago, where the Planning Commission and the Landmarks Commission now are somehow in the same agency. It's an interesting phenomenon because what I see from the perspective of my clients who I represent when I go to the City Planning Commission, that they're often surprised by the disconnect between the agencies. So you can actually be designing a building that the City Planning Commission is in favor of, and then it comes to landmarks and it's killed, actually. We've actually had some of those experiences on the commission where there was a total disconnect between the agencies, and that's something where I really think that the law needs to work, that the two agencies need to work closer together, the law itself needs to be blended, because in fact historic preservation is planning. It's an urban planning process that needs to recognize the role of zoning, and zoning needs to recognize the role of planning, of historic preservation, because the other aspect of it is, of course, we see many times people coming in to add very large additions to their little tiny townhouses. And why can they do that? Because they're located in zoning districts that allow them to quadruple the size of their house. So there's a total disconnect between the purpose of preservation and the zoning purpose there, and those things really need to be coordinated.
David, I'm going to direct the next question to you to get the first shot at. And that's, we've heard that our landmarks law was really the gold standard when it was passed, many wonderful limitations, but there have been now decades of law, decades of experience. We heard about some other laws this morning. The question, I'll try and make this one more specific, is, have you observed anything, or are there any aspects of other laws, other ordinances, have things evolved that if we were doing our landmarks law over again today, is there something that we can see from others that that you would like to incorporate into it? I'll just add that if indeed I understood correctly from Tersh, I really like the idea that you don't have to go to the city council for designations to be approved. But that's just me. But anyway, so David, you start with this question and then others can jump in.
Right, so I think, one of the things that's interesting is we talk about Penn Central all the time when we talk about our landmarks law, but Penn Central sort of fundamentally changed the way we think of the ability to regulate property. It set a standard. It did address sort of, to the degree that it addressed when a regulation goes too far, it arguably ratcheted up the government's ability to regulate property shy of a taking. And I think that some of the underpinning of our landmarks law, particularly the hardship area, my slideshow went a little bit long, but as a very brief aside, we have a hardship variance built into our landmarks law for for-profit entities as well as for certain nonprofit entities, but not for nonprofit entities who wish to demolish or alter in an inappropriate way their historic resources. So this is the sort of the underpinning of the St. Vincent's issue. One of the things that we've seen is that when the landmarks law was enacted and when some of the case law that addressed the question of what do we do in the absence of a statutory answer to the question of a nonprofit owner who wants to demolish a building, we've seen that the takings law that underpins our landmarks law has been ratcheted up. And the problem, I think, at St. Vincent's was that our own ordinance maybe didn't allow, it arguably was very desirable to have some flexibility built into the way our Landmarks Commission would have been able to deal with what was a very difficult set of facts. But the law that underpins our landmarks law had sort of outgrown the landmarks law. Right? We have Penn Central, we have St. Bart's, but the the case law and the ordinance themselves sort of didn't really do the work. And so I would say that one thing we could think about doing is taking a look at where we would like our statute to deviate from its underpinning law and actually codify some of those things. So some of the things that have changed throughout case law, it might be legally true, and we certainly have a federal floor. If the Supreme Court says it, it is so. But we do have some freedom to nuance the way our Landmarks Commission can deal with some of the law. And I think to that extent, that's something that would be desirable and update. A lot of landmarks ordinances that were passed subsequent to St. Bart's, for instance, have statutorily incorporated some of the holdings in the St. Bart's decision, which is really just a great attempt at bringing the for-profit Penn Central analysis into the nonprofit world. And it's really difficult. If you think it's hard to figure out when a regulation divests an owner of its monetary value, it's even harder to find out if a nonprofit owner has been divested of its ability to further its charitable mission. Like this is tough stuff. It's heavy lifting. And with all respect to the commission and to the commission staff, I think rather than let them figure it out on an ad hoc basis, we might want to codify some of the things that we think should be in there.
Okay, Al, so you-
Yeah, I'd sort of like to make a case. I think we were extremely fortunate to have the landmarks law as amended in 1973 adopted at all. I think it's remarkable. And while I agree that there are some aspects of it that might be legislatively improved, one is designation, maybe we'll talk about that a little later. The landmarks law was created, I suppose, mostly because people thought about Greenwich Village and people thought about Grand Central and the like. But the reality is it has emerged as one of the preeminent ways of trying to protect neighborhoods. And neighborhoods is place. That's where people live. And so I have to dissent a little bit from what Marjorie had to say, because why shouldn't it be zoning? Maybe it should be zoning, but it isn't zoning in this political atmosphere. Zoning in this atmosphere, I shouldn't make an across-the-board condemnation because the City Planning Commission has downzoned a lot of neighborhoods and is trying to protect neighborhoods. But the landmarks law is absolutely the best mechanism to protect neighborhoods for those areas that have been designated historic districts. And if they had been, they presumably deserved to be. And I think we're fortunate to be able to take advantage of the landmarks law. I think that Mark's comments are reflective of what often happens with agencies that are entrusted to carry out a particular mission. The mission of the Landmarks Law Agency is to protect historic resources. When Mark talks about discretion, there's a lot of discretion in the law. In terms of designation, the city council has the opportunity to veto and has done so in particular situations. In the case of hardship, there's a hardship panel that's never been invoked, and presumably the council can change the situation if they want. I think the agency should be doing everything it can to implement the landmarks law and not to worry about the other considerations of policy. Those are for the legislature to determine if they want to revisit the law. The Landmarks Commission, which is distinct from the Planning Commission, ought to be upholding the landmarks law and using it to the broadest possible extent now that it has been established as legal.
Let me just add a thought on that. One of the things that's missing from the landmarks law is a mechanism to reconcile conflicting city policy. The Landmarks Commission has taken into account on various occasions, I'll give you one example, which is the demolition of the Purchase building under the Brooklyn Bridge. There, the compelling desire of those interested in Brooklyn Bridge Park to open a vista. It was a parks and recreation policy. That policy overwhelmed the public interest in preservation. One would think that a conflict in policy of that sort should be resolved by the city council through a political process, instead of internally at the Landmarks Commission deciding whether it will defer to the policy of a different agency. There have been other such examples, and indeed the St. Vincent's in its own way represents a conflict of policy in the city. Obviously a great desire to do good things for the hospital. At the same time, we have the public interest in preservation. Interestingly, the landmarks law on its face does not provide any mechanism for reconciling, compromising, or otherwise dealing with conflicts of city policy. Now, when the purchase building came along, I made an argument that the Landmarks Commission had no business taking into account the public policy having to do with the park. Because if you go to look at the terms of the landmarks law and the definition of what can be considered on the issue of demolition, you don't find in there anywhere the idea that, well, if another agency has a compelling policy need, you can defer to that. That's not one of the listed items that you take into account when you are deciding under the landmarks law whether demolition is appropriate. And I just give that as an example. I think the St. Vincent's thing involves another example. Another example that's going to come along is the conflict between preservation policy on the one hand in connection with a landmark building and the desire of a large number of people in the city to convert it into a theater. We're constantly being confronted by these kinds of policy choices, and nowhere is there a mechanism specified politically to resolve those kinds of things.
Mark, last few words on this one?
Yeah, just a couple things. One is that, with respect to the purchase building, I think it's important that, two things to note. One is, there is a provision in the law that the drafters created to deal with conflicts between city agencies, and that was originally that the Landmarks Commission was advisory. So that when we came up against city-owned projects and city-owned property, all we could do was issue an advisory report on the theory that every city agency has its own mandate, new housing for the poor, parks, whatever it might be, and the Landmarks Commission would be part of that process. They would come to us, we would say our opinion out loud, in the political world, and then it could be disregarded unless the public then organized and defended it. That's changed. I think, ironically, it changed inadvertently with the passage of the amendment to the Art Commission law, so that now the Landmarks Commission is binding on, in certain respects, it's very complicated and it's supposed to be streamlining things, maybe it doesn't work that well, but now we are in fact binding in some cases where we were binding before. So I think there was a very explicit political calculus in the original law, but it wasn't as, you're correct, it wasn't like a face-to-face debate. It would happen sort of seriatim, and the agency that wanted to do something could just sort of do it afterwards, after the hubbub died down, if it did. Now, but I do want to just go back briefly to what the question of amending the law, because we're all talking about this in preparation for this, and I think that Otis said that we were all talking about should we amend the law? Is it a good time? And Otis pointed out, as someone who's been around for the longest, said there's no answer to that question. It all depends on circumstances. It all depends on where we are at a particular moment with a particular council and a particular issue, and where the public is at a particular moment. And I think that's really true. And I think that because it's easy for me to say, you can amend the law, because that's why I was brought to the Landmarks Commission in 1995. I was brought specifically because I had a lobbying background to help the then chair, Jennifer Rabb, amend the law, which we did successfully, to give the commission real enforcement power, which has had real impacts on the landmarks law in New York City. And John Weiss is going to talk about it a little later. And so it can be done, but it was done in a way that is a very specific issue. It was very narrowly drawn. You had a very strong chair with very strong ties to the mayor. You had a very strong head of the landmarks subcommittee in the city council. And it was a way to be controlled. At no time during that process, having been a participant in it, was there any risk that it was going to spiral out of control. That said, guess what happened? We didn't get everything we wanted. The nonprofits, the religious organizations came in and said, and basically we got the message from the Speaker's office, if you don't cut out the religious organizations, the whole bill's dead. So guess what we did? We cut out the religious organizations. Now, later we got it back in, so we have demolition by neglect for nonprofits, but we still had to do it. I think that when you start talking about amending the hardship provision, I think it'd be very, very, very difficult to control that debate and to control what's open at any given time. And that would be my biggest concern, is I think that it would be, there are lots of, if you look at what the Real Estate Board of New York is proposing for the charter, they want lots of limits on what the Landmarks Commission can do. This is exactly, some having to do with hardship. It's exactly a vehicle to bring all those in. And I think that's the danger, is that to amend it, it has to be something very specific, very narrow, and a hardship is not one of those issues.
Okay, I'm going to reconvene the panel over a bottle of wine to have them answer the other 10 questions I had. But we are going to turn to the audience, so if the people carrying the microphones would position themselves, we'll open it to the audience. I do want to just leave with the thought, kind of building on what Mark said, is, for years, no card-carrying preservationist could even raise the question of whether we should try and amend the law to make it stronger without being voted off the island. So I think it's healthy that we're finally at a place where we can have a conversation about whether indeed there are ways to improve the law and whether it's politically wise to try and move on those. So I think it's a wonderfully healthy conversation. People have extremely strong opinions on it. So let's open it up for some questions from the audience to the panel on our large issue of perpetually young or looking for Botox. On that note, do I see any hands?
Yes, you do.
Oh, Simeon.
Hi there. Something actually, just picking up on what Brian had said earlier from learning lessons from other municipalities, the notion of thematic districts. Could you sort of discuss what might be I know what the upsides of it are, but what could you just discuss your feelings about that, what might be possible disadvantages or why it would not work currently?
In the context of New York City.
In the context of New York City,
Okay.
please.
What was the
Thematic districts.
Thematic.
Where, for example, and Brian can answer this better, but you were to look at a series of African American historical sites and kind of create a thematic district of that, or as he did with neighborhood banks.
Okay, and before the panel answers that, I'm now going to go into the strict moderator mode, and I don't want every panelist to answer. So if you really want to answer, signal, otherwise hold your fire for the question you really do want to answer, because everyone's not going to get to respond to every question. That being said, who would like to respond? Mark, go for it.
I think that it's a good idea. I think we have to be careful about words, though. It's not a district, as we use the word district in New York. Okay, it's thematic designations create a way to, when Brian and Lisa Kersavage and Marcy Revens and I were all talking about this afterwards, it's a way to create a milieu and a rationale and a basis for designating lots of different things, that all of which would take too much time individually, and also you might be able to be able to throw into the mix things that on its face would be more difficult to get. So I think that it's a great idea. I mean, the commission, the closest we've done is this sort of federals, sort of looking at federals and sort of trying to do more federal buildings, but it's not been done all at once. It's been done seriatim, and I think it's an interesting idea and one that certainly we're going to look at.
Okay, questions. If I got my list of 12, I'm happy to go to them. Here's Roberta Gratz here in front.
I can't say I've been around as long as Otis, but I may be the second longest in the House. I'm not sure whether this is an observation, a challenge, question, or a comment, but I'm always a little concerned about this need to separate the planning from the landmarks and zoning from landmarks, all of which obviously is clear in the law. But let's remember that the law was an outgrowth of urban renewal overkill. So from day one, there has been a blurring of what the use of the landmarks law was for. It was reactive. And yes, Marjorie, a lot of people do respond to threats in their neighborhood through landmarks. However, it's often that threat that prompts them to care about what is of preservation value. I have not seen in our history any neighborhood using the landmarks law inappropriately. It may have been spurred by what you described, but its use was not inappropriate in that they weren't fighting for something that had historic value. But so I think we have to also remember that history has blended it from day one. And as was just often said before and said over and over again, the Grand Central case didn't just change historic preservation. It changed land use planning and policy nationwide. But that's land use. That's not just historic preservation. So I also want to add, though, that I think I totally agree with Mark on needing to keep any attempt to refine the law to a narrow opportunity, because there was a time when there was an attempt to change the law, when they were ready to drive a Mack truck through it, and the whole thing was squelched just for that reason. And that's very important to keep in mind.
You go for it.
Yeah, I have a comment. It's really not, I mean, I don't think there was a question there. But with respect to, this was another thing that I think, again, was raised in the subject of Chicago. I mean, I don't know what the building count now is with all of the property, all of the, how many, 110 historic districts?
Over 27,000 buildings.
Currently 27,000 within all the historic districts. And so there's this landmark staff of 60, and I don't know which percentage of them are the ones who actually review the applications, but what is it, 30 who review the applications?
Far fewer. It's about 15.
Okay, so there's 15 people who review the applications for potentially close to 30,000 buildings, and as we move ahead, there'll be way more than 30,000 buildings. And so you have to ask then, what is it that we're doing here? I mean, you have a property owner who wants to change windows, and they want to do it in a way that, let's just say, it's staff level approval. Nevertheless, it's staff level approval, and the staff has thousands and thousands and thousands of applications. And I guess the question is, when there was a move to expand the Upper West Side Historic District to encompass another, I don't know how many thousands of buildings, are what we really getting at historic preservation, or is it something that's zoning-like? Because what we're trying to do is retain something about the character. What's attracting us to the neighborhood has to do with scale. It has to do with materials. It has to do with sort of much broader things than maybe that person's windows. So maybe what's missing either from the landmarks law or from zoning mechanisms is a mechanism that's somewhere in there. It's a conversation I've had before that I call landmarks light. It's not the same kind of a regulation that we're currently imposing on every property owner. There needs to be much more of a range so that maybe another agency can manage it, or another kind, maybe it's something that's very clearly in a set of guidelines or a building code or something. But I'm imagining 300,000 buildings that 15
just
people
to tee this up, I
regulate.
think we'll have a presentation in the next session that may be floating some ideas around that. Al?
Yeah, I think that zoning doesn't save character. I think that's one of the limits of zoning. I mean, it can keep things smaller, it can keep things big, even contextually, where you have an existing neighborhood, brownstones or whatever, it can help there. But that's what distinguishes the landmark law. The landmark law takes the community, which is what people are really talking about, and tries to maintain the character of that community by preserving mainly the structures that exist. If we were in Europe, no one would be thinking twice about this, because that's the way hamlets are, that's the way cities are, and the like. Well, I shouldn't say all of them, but certainly the best of them. And I think with regard to the issue of how you enforce all this, there are lots of possibilities, including self-certification, including giving neighbors the rights of private action in order to enforce the regulations and the like. I don't think it's an endless process of bureaucracy that has to go on.
May I jump in on that note just for a moment? For 20 years, I've been trying to make this point. I might as well make it again.
That time,
So
the
I've
time
now
is
joined
right.
you.
Well, 20 years ago, I proposed in something called the Historic City Committee report the idea that we could solve our enforcement issues here, I should say, with nearly 30,000 buildings. I think we've got 2 active, am I right, my count right? 3 active enforcement people for 110 historic districts and close to 30,000. So, you know, the idea that we are closely monitoring what's going on in all these historic districts, I think, is pretty self-evident. But if we could, with a very simple change in a few words, adopt what the federal environmental laws adopt, what the federal securities laws include, what the federal antitrust laws include, a private right of action, the private attorney general. Not everybody would be able to do this, but organizations that have been around for a while, you could spend a lot of time trying to define exactly what the criteria are, but take it from me, it would be possible to identify criteria that would eliminate the cranks and the people who have grudge matches, and you could open to responsible organizations the ability to assist in policing the enforcement of the landmarks law by creating a private right of action. You would only be entitled to get injunctive relief. This is not going to be for damages, but in a trice. Now, the Landmarks Commission has never liked this idea, which is why nothing's ever happened. Dorothy Minor hated this idea. She hated this idea. We had the most terrible fights about this because the landmark is perfectly understandable. And I know that where Mark is going to come from. He doesn't even need to bother because I'll state it for him. They want to keep control of the process. Understandably, if they keep control of the process, they can determine what's going to be pursued, what isn't going to be pursued, all the subtleties in the litigation that pursues it. And I agree that something would be lost, but the Landmarks Commission obviously could always intervene in such proceedings and make its will felt through that means. I think there's an answer to all of the objections, and one should just step back and understand the incredible benefits that enforcement would achieve by having a private right of action.
Mark, would you like to expand on his statement of your position just a little? Or?
Well, it was well stated, but I think I want to move, actually take the conversation a little bit further on, but I think that I would say that everything that Otis has said is certainly the position of the Landmarks Commission, but in addition, I think it is very difficult to weed out the cranks. And I think that, we deal with this every day, and I think it's one of those things where people who think about preservation sort of from on high need to come back down to the hearing once in a while. And I'm not saying, people come into hearing, they propose something, and it's routine for preservationists in neighborhoods to basically try to humiliate and demonize their neighbors. It is a very unpleasant, actually, often, forum. Some families bought a house, they want to put on an addition, and they're told this house, first of all, the house you have is a piece of crap. Even though it's a piece of crap, we think what you're proposing makes it worse. So you're a piece of crap, and I think that it's really, people cry at these things. So I think that don't underestimate the sort of the sort of power of neighbors to get involved in their neighbors' lives in a not a productive way. I also want to raise, though, a different question, which is I think there's a lot of conversations that happen all the time in New York about preservation and what the public wants, and I think it all takes place with an incredible lack of information about what the public really thinks about and values about what I and the rest of the people at the Commission do every day. I mean, and sort of following up a little bit what Marjorie said, you know, for instance, windows, you know, materiality, one of the cornerstones of historic preservation as we now know it, and certainly the way the landmarks law in New York City is created. How important is that for these neighbors, these communities that want to preserve themselves? Maybe it is a question of just size. Maybe that really is. I think that we need real metrics. We need to go out and talk to people about what it is that they value and like about what we do, how well are we doing it, and what they hate, and what it is that they don't value and think is intrusive, so that we can actually be an actual discussion of what does preservation mean to New Yorkers. Because, you know, this conversation happens up here, and I'm telling you, the rest of us are down here dealing with people who bought into the violation. You know, the people who, you know, there's a case, you know, we're dealing with now. You know, these people bought a house. Guess what happened? 20 years ago, because there's no private right of action according to Otis, someone changed the curved parlor floor windows on the brownstone. Okay, these people bought it. There was no violation on the property. There's nothing. They bought it. We now find out about it through whatever means. And guess what? What do? Do we say you now have to come up with $50,000? And that's not a made-up number. To change curved windows? That's what the commission has to do every day. And I think that it's really, when we talk about preservation, we need to say, what is it that people value in New York about what we do?
Okay, Frank, you're next, but before you start to talk, raise hands again, because I want to tee up the next few questions. So who else is, just want to make sure, oh, this side of the room. Okay, we'll go to this side after Frank, so if the mic will go, second mic goes over here. And Frank has the floor, but I just want to point out for the record, I see no cranks in this audience. Frank?
Okay, thank you. My question is about making the landmarks process more easily understood by the public. And landmarks regulation through the commission is about regulating private property. But Mark just talked about a change where the commission now has binding authority over properties owned by the city, which are governmentally owned and public property. It's always been confusing to me, and I can't imagine that it isn't to others, that the commission's decision about state and federally owned properties in the city are also advisory. And in fact, the commission spends time considering proposed alterations to some of our most important and visible public buildings that the public would probably assume the commission had authority over, and then those agencies completely ignore the finding of the Landmarks Commission, and all the time that was invested in that is more or less down the tubes. So my question is there any way that you think that relationship between the findings of a municipal authority having any sort of more binding constraints upon publicly owned or governmentally owned buildings can be sort of addressed?
Okay, if a couple people want to take that on, or nobody wants to
You
take
have
it
to have
on?
an opinion on this, yeah.
Yeah, I have an opinion on everything, so. You know, I said the legislature ought to decide. When you get to public properties, there's a public government, and I agree with what Mark said. Maybe the provision that restricts the Landmarks Commission so its decisions are obligatory rather than just advisory is a mistake. You know, when it's in the public realm, the political process basically, in my view, appropriately decides what should happen there.
Okay, we have a question here. I want to line up the next question. Did I see it handed back? Jeffrey, was your hand up or not? I don't want to. Nope, okay. There. Okay.
Hi. I'm wondering, in the opinion probably of Mark and Al, probably are more suitable in answering this, is in your opinion, to what extent are not-for-profit organizations such as the St. Vincent's or a city agency like Parks really delaying a building actually having a hearing, or even ever getting a hearing, or actually ever being calendared? Because with not-for-profit organizations, it can be something that will take years and years and years to ever see a hearing because it's owned by a not-for-profit. So I guess the threat of something being not-for-profit owned, the ramifications of actually having a property like that ever designated or being managed by historic preservation district.
We get it, okay?
I think, and Al will jump in because he referred to his.
I'll
case
go
earlier.
first, sorry, Mark.
Oh, you're going to go first?
No,
Oh. You know, it's not just, of course, the issue you raise is not just about nonprofits. It's about the designation process. And the landmarks law, there's been, as it was referred to a couple different times during the course of the day, there's been some litigation in New York about that process. And the landmarks law, and the commission has prevailed in all those cases, and because the landmarks law itself is silent on how things are brought forward. Once a decision is made to actually consider something formally for a landmark, a lot of due process things kick in, and there's hearings and reports and things go on. And that process before then is a process that takes place at the staff level, and David's slide was talking about sort of the importance of the staff. And so there is, you know, I think that the commission, the short answer to your question is there's been some criticism about the sort of lack of communication about what happens. Where is something in the process, in sort of the review process for potential landmarks? And the commission you know, we keep saying this, it keeps getting delayed, but there's a big capital project to bring all the computer stuff together in the city. And so soon, now it's June of this year, people will be able to look online on a property and see every permit, every violation, designation information, staff level permits, commission level permit, the whole thing. In addition, RFEs, the requests for evaluation, will be the status of those will be there on the website. So you can actually see, it was submitted on this date, and it's under consideration. That said, that internal process, I think it's very important, and it's not an answer that preservationists like to hear, but there's a lot of priority setting and decision making that happens at the level of the chair and the staff to sort of deal with the fact that we get 200 requests for evaluation every year, and that's a request is for one individual building or for a huge district. We have to deal with priority issues, you know, sort of budget issues. There's a lot of decisions that go on in terms of whether something should go forward or not. And that decision making, I think, is appropriately currently resides with the chair and sort of that internal process. You know, and because I think it's inevitable. You know, for example, the current chair has the outer borough. Designations in the outer borough was something that he has talked a lot about since he was first appointed in 2003. Since he's been there, guess what? More than like half of all of the designations in Queens now. He's doubled them in Queens. He's increased designations in Brooklyn 15%. That's a priority. Now, should he be able to say that takes priority over everything else? You know, there is a process that commissioners, you know, not that he sets every single thing, but those kind of priorities are important because we have limited resources. Working on one thing means we're not working on another. So in that sense, I think that's the process, and it's a practical process given a volunteer commission that meets, you know, 3 times a month. 15% of Marjorie's professional life is donated to the city of New York. 15%. And we can't take up more of their time. The staff has to make these decisions.
Wait, I want to let Al respond.
Mark's beat me in court, so if he's speaking out of the right side of the
just
mouth.
not say anything else.
But I represent a group called Save St. Vincent de Paul, which is not-for-profit, trying to save actually the first integrated church in New York by more than 70 years. It's called St. Vincent de Paul. It's on 23rd Street between 6th and 7th Avenue. It's a French-speaking church, really. It's been, you know, found eligible by the State Historic Preservation Office, and it's actually a very attractive little church. And it has, because of its history, Edith Piaf was married in it, so, I mean, she's only married 17 times, so there aren't not that many places where you have this. So it fits, it fits every possible criteria of a structure that ought to be at least considered for designation. And we submitted a request in EAF or EAS, whatever they're called, and we're denied on the grounds it doesn't meet the criteria, the usual 3-line letter that tells you it doesn't meet the criteria, and brought a lawsuit saying the landmarks law says the commission is supposed to designate or determine, and that implies the commission should determine what is heard or not heard, rather than just the chairman, and we lost that. And we think that there needs to be, if there's any amendment to the landmarks law that's ever proposed, given this climate, that's one that ought to be made. In Boston, citizens can nominate structures for designation or districts for designation, and we're suggesting a proposal which would allow that to happen. But if a citizen does it, in order to get rid of the kooks that Mark's talking about, they have to bring with them a report from a qualified historic preservation expert laying out what the reasons are for designation. Then the full commission hears that, only in a preliminary way. And if they decide it needs to go on, then it goes on. If they decide it doesn't need to go on, it stops. And so that way you avoid increasing the workload geometrically, but you provide a process for the public or important people in the public to make. Whether that happens or not, I don't know.
Okay, back there.
Just wondering whether the LPC of the greatest city in the world shouldn't be, at this point, with the workload, be composed of full-time commissioners. Why is it that just the chair is full-time? Of course, there are budget problems and so on, but are we at the point where we could do so much more and when we have the full attention of X number of commissioners? Is that outrageous?
No, that's right.
Marjorie?
Well, we have 85. We still have 85% of Marjorie's time to take advantage of.
If a board of standards and appeals, it's not as important as the landmarks commission.
Yeah, it's interesting. There is a, as one can imagine, there's a philosophy that is still adhered to by, I don't really know, since, like I said, we have no metrics, some percentage of the preservation world that believes that volunteer commissioners are really important, that you need to have people that are not viewing, the job of landmark commissioner as, a paid job, that you'll get better people if it's not paid. I think it's problematic, because I think there are structural issues that follow from having an unpaid commission, and I think it's probably something that should be looked at.
I just want to speak to that. The city planning commissioners are paid, but they're also working full-time in their other jobs. They're paid because the time spent is recognized. I don't believe that them being paid has an impact on their decision-making. It just recognizes their time. I think it's very important, personally, that the commissioners on all of these agencies be professionals, that they're not full-time government employees, because, for instance, for me, I'm every day, on the days that I'm not at the commission, representing property owners who are confronted with the various regulatory processes. So as a result, I can be empathetic to that property owner who owns a house that's got a window that was replaced 20 years ago. And how do we address the realities of it's not historically correct replacement, but at the same time it's a person with limited income and so on. And I can be sympathetic also because I understand, as a professional, I'm also an architect, so I understand how it is to modify a building and what's entailed, and can read plans, and the other architects on the commission, it's important that they do that. And the person who's in the real estate business understands what kinds of impact on real estate. It's very important that you have active working professionals who listen to working professionals make the presentations and can kind of weigh reality checks.
Okay, we're down to the final round of Jeopardy here. We have about 7 minutes left, so anyone who is dying to ask a question, please demonstrate vociferously so we give you a chance to do so. I see a hand in back.
To go back to Frank Sanchez's question, the City of Los Angeles uses the California Environmental Quality Act as a tool to enhance landmark review. And we could have, in New York, under state and federal law and city law, a memorandum of understanding as to how to use the environmental impact assessment procedures so that state and federal agencies would have to listen to the Landmarks Commission's advice as a matter of expertise, not as a matter of a mandatory decision. And I've always wondered why the city doesn't choose to engage. City adopted an environmental impact assessment law before any other entity after Congress, before the state of New York. We copied the California law when we adopted our law in 1978. You could integrate each of these environmental impact assessment reviews through a memorandum of understanding. And it would just take a little interagency negotiation. And then you might get to Otis's point that you could have some judicial review of that if citizens thought the reviews were inadequate, because there's a large body of case law on that. That's a soft question for Al Butzel.
No. I believe, and Mark will have to talk to this, that the LPC does not regard itself as subject to the environmental EIS laws, and therefore maybe it would be difficult for them to integrate anyone into the process.
Yes, I mean, the commission has taken the position legally and had been adopted that the commission is not subject to the Environmental Quality Review Acts because, as Professor Caden mentioned earlier, we view our decision-making is on very narrow grounds. It's set forth in the statute. It's about architecture. It's about, you know, the things that make a particular designation significant, and that has been upheld. So we are deemed to be ministerial in our review. And
which is just making my case that when he starts talking about outside considerations like equity and that sort of thing, it must be illegal, right?
I don't believe I've used the word equity today.
I used the word equity to give you credit.
Okay, Frank will give you
So
one.
not to belabor, but in this discussion that Nick and I are asking about, if you're going to take the position, or if the position is that it's not subject to this, is it worth taking the time of the commission and the commissioners in talking about federal and state buildings if in the end nothing comes of it?
I think that absolutely it is, because I think that the process, just as it was with the original landmarks law, where we were advisory on city-owned projects, politics matters, and that these are meaningful interactions. That doesn't mean they agree with everything that we say or we do, which is fine. But I think that, you know, when we deal with the federal, you know, the Parks Department or the Park Service, or when we deal with the sort of larger state authorities and stuff, they do listen, and they do sometimes adopt. Not every time, and sometimes it's a problem, but I think dragging them before the Landmarks Commission and having them sort of explain what they want, hearing the questions and the criticism, can have a salutary impact on some of these things. I mean, I think the TWA terminal example was, I think, again, is it the outcome everyone wanted? No. But I think the fact that they had to come to the Landmarks Commission and defend their view and explain it mattered, and the project that resulted was better for it.
I think on that note, I think we should all thank this panel. It's been really terrific of them to come and talk. We are into our second coffee break. I think they just pulled it. We'll start again promptly in 12 minutes.